Mr. Kirschner's next, and then we'll have Dora Chen. Good afternoon.
Good afternoon, Chairman Liebman and members of the board. I'm Curt Kirschner of Jones Day, speaking on behalf of the American Hospital Association and the American Society of Healthcare Human Resources Administration. The AHA represents more than 5,000 hospitals, health systems, and other healthcare organizations and 42,000 individual members. ASHHRA represents over 2,900 human resources healthcare professionals who serve in our nation's hospitals. AHA members run the gamut from large hospitals and health systems to small rural hospitals. Over 40% of our nation's hospitals are standalone hospitals, often the sole healthcare provider for their communities. The burdens placed on these organizations affect the delivery of patient care throughout the country. The hospital community has significant concerns about the extensive rule changes proposed by the board. The AHA and ASHHRA will be submitting written comments during the period allowed by the board. In light of the limited time available today, I'm going to only address the following 4 points. First, the board's process in proposing these amendments is inconsistent with President Obama's executive order, the board's own prior practices, and provides an inadequate opportunity for genuine public discussion about the proposed rule changes. Second, the inadequate process leaves unanswered many questions about the actual net effect of so many changes occurring simultaneously, in particular with respect to the statement of position. Third, the board's proposal to have employers produce overlapping employee lists on an expedited basis would impose unfair burdens on employers and place well-intentioned employers at the undue risk of violating the Act. And fourth, electronic signatures should not be accepted for the purposes of mandatory showing of interest in representation cases. Starting with the first point, the NLRB's process appears to be inconsistent with President Obama's executive order with respect to the publishing of new rules. Executive Order 13563 provides that, quote, before issuing a notice of proposed rulemaking, each agency, where feasible and appropriate, shall seek the views of those who are likely to be affected, including those who are likely to benefit from, and those who are potentially subject to such rulemaking. The board's cursory explanation in footnote 34 of the proposed rules that such advanced discussion was not provided in order to obtain more orderly comments fails to demonstrate why advance and genuine dialogue on such extensive and important rule changes was neither feasible nor appropriate. Spanning 35 three-column pages in the Federal Register, the proposed changes amend the board's entire election process from start to finish. The only board rule changes of somewhat comparable significance in the recent past relate to the establishment of appropriate bargaining units in acute care hospitals, with which the AHA was extensively involved. In those rule-changing procedures, the NLRB gave interested parties substantial opportunity to participate in the rulemaking process, including advance notice, regional meetings, an opportunity to cross-examine, and a second notice with an extensive comment period. This process did not end all disputes, but it allowed all parties to vet their concerns and allowed the board to set rule changes that withstood court review, including by the United States Supreme Court. Here, the board's rule changes modify over 100 sections of its election rules and affect a much broader scope of employers than the acute care rules. But the process being afforded by the board appears truncated and almost perfunctory. The second point, this lack of adequate process leaves unanswered many questions about the actual net effect of the rule changes. With so many overlapping and simultaneous changes, I think it's difficult to determine exactly what the effect will be of these. So for example, with the compulsory statement of position, in the context of providing that in an expedited time frame, this may result in employers or respondents doing what defendants normally do in civil litigation in their answers, which is to assert as many defenses as possible in order to avoid waiver. Employers will be forced essentially to put as much down on the paper to avoid waiver. Currently, board procedures result in election agreements in approximately 90% of all cases. These cases on average are resolved much more expeditiously than contested cases. But the net effect of the statement of position, the compulsory statement of position, could be that you're going to end up with further contested hearings and thus more delay in actually holding the elections. We would suggest that the board adopt for all of its rules the process that the board is using with respect to blocking charges. That is to raise questions about that, to investigate and get opinions on this. And if the board was truly interested in reducing the time period for elections, the board should look strongly at the blocking charge issue. Although the board does not publish data on this, and it has been requested of the board, based on a published 2008 study, it appears that blocking charges comprise one of the most significant, if not the most significant, delay in representation cases, increasing the length of time to an election by about 100 days. So we would request that the board revisit its process and actually raise questions about the election process before and not proceed with the current proposed rules. The third point that I'd like to raise just briefly is that the process of overlapping lists of employees is going to place unfair burdens on employers. Hospital employers, like most employers, do not have their IT system set up so that they can, with a push of a button, push out lists of employees that are consistent with the way in which the board's rules are. So, for example, identifying who's technical versus who's professional. Even more importantly, who meets the multi-factored test of who's a supervisor and who doesn't. Having employers be forced to produce multiple versions of those lists in a short period of time places undue burden on employers and puts well-meaning employers at the risk of violating the law. And then the final point is just that there's been no showing that there's any reason to accept electronic signatures for the mandatory showing of interest. That would be pose significant administrative burdens in evaluating whether a valid showing of interest exists, and it creates a high potential for fraud and abuse. Thank you very much.
Thank you, Mr. Kirschner. Questions?
I've got what may seem like a technical question, but your association obviously represents a very broad spectrum of types of healthcare providers.
Correct.
And has led to simple R cases and incredibly complex R cases, and several have gone up to the Supreme Court. So a very wide spectrum of types of cases and types of employers and types of units that have been petitioned for. The 7-day proposal, as the NPRM suggests, the 7 days is taken to be consistent with Croft Metals, where the previous board held that was the minimum period considered consistent with due process and with the Act. But the proposal is currently to qualify that to say, except for in special circumstances. And we specifically invited comment on, is that the right term? So I guess my question is, given the wide variety of types of employers in your associations, wide variety of types of R cases, do you have any thoughts about what would be the appropriate qualifying term to accommodate the types of concerns you're describing in preparation?
I believe to answer that question, you would need to know what is the employer required to do by the commencement of the hearing. If the employer has to walk in the door with a statement of position that definitively sets forth all positions at the risk of waiver, has a list of the requested employees who'd be under the union's list, and has a second list that has all of the employees listed on the employer's proposed list, I think 7 days is inappropriate. I think that, as I stated before, the mandate that the employer set forth all positions at the risk of waiver places employers, especially on such an expedited time frame, in a position where they are going to be forced effectively to put in more defenses than they otherwise would under the current rules. Under the current rules, the board is successful, the parties are successful in reaching agreement in almost all cases. And I really fear that the expedited process that you're going down is going to result in people just automatically going to the hearing, putting out the required information, and then letting the hearing officer sort through that. And I think that's going to result in more contested elections and ultimately, therefore, a longer time period to get to the election than what you see in the current rules. But I think more dialogue about this would help ferret that out, and we would see how these different rule changes could possibly affect the actual process.
Well, wouldn't you say that the way the current rules are now, the current process is, and in my experience as a practitioner, makes me recall that in a representation proceeding where the parties have no obligation to provide any information with regard to issues, you find parties showing up and some parties feeling blindsided, and the board even being blindsided by positions that are presented at the 11th hour or on the fly, which oftentimes creates the need for a continuance and a protracted nature of the process. In this proposal, not only do you have a statement of position, but there's a requirement of an offer of proof relative to the issues at hand. Don't you think that should eliminate a problem that currently exists?
With respect to the problem that currently exists, I am not here, the ASHHRA is not here to try to defend bad actors. If people try to abuse the process, and you can see that on all sides of this situation, I think that there are ways to address that issue that are well short of the proposed rules that you're making. So, for example, requiring an employer to state a position, I don't think is nearly as complicated of a rule change as what the board has put forward. And I think that may help address some of the abuse that you might be referring to. But I'll also go back to the statistics. In 90% of all cases, an agreement is reached. And so the aberration, the abuse that may occur may be something that needs to be fixed, but it should not drive a wholesale change to the entire election procedure. And it's very important in that agreement that the parties understand who is eligible to vote and who's not. The supervisory issue is critically important to determine who is the employer needing to train in order to ensure that that person doesn't inadvertently violate the law. So, for example, one conversation between two employees about the union may be entirely fine. Or if one of those persons happens to be a supervisor and they ask the other one, what do you think about the election? And if that person's actually a supervisor, that the employer has now just violated the law under the current rules. And so identifying in advance who is a supervisor is critically important. And I think that's one thing that happens under the current rules now, is that because so many petitions end up in getting a stipulated election or consent election, I think the parties work out in advance largely who is going to be a supervisor and who's not, and that's very important to the process.
The proposed rules would not abandon those opportunities. In fact, as was stated earlier, that 90% of stipulated elections should continue. The proposed rules seek to scale down the process that comes to light as a result of those issues that cannot be stipulated to, or where parties do not reach agreement. So, and of course, the statistics, as I recited earlier, with respect to those current cases where there is no stipulation, are pretty. We're talking about the time period between election and petition and election, far exceeding that 38 number.
Correct. I think the average would be 58 days. And where there's a blocking charge, it can be substantially longer to actually having the election. So there are many moving pieces here. Our request to the board is that it carefully think through how these different pieces are going to affect each other, and so it can come up with a set of rule changes that are actually going to meet the goals of the board and not themselves inadvertently put employers at risk and delay the election process.
Thank you for your thoughtful comments.
Thank you.
Appreciate your participation.